Hello and welcome. My name is Elena Pop. I'm the Executive Director of the Eviction Defense Network, also known as EDEN or EDN. Before watching this video, please watch our two introductory videos, How to Get Help from EDEN and From Zoom to Victory. You should also watch How to Respond to a Notice from My Landlord and How to Respond to the Summons. This video series builds on previous videos. Most of our videos apply to evictions in the County of Los Angeles. This video is generic enough to be useful to any tenant facing eviction, regardless of where they live. This video is intended to be used with our webinars and empowerment classes. This video does not replace legal advice or an assessment of your case by a lawyer, but it will make you a powerful eviction litigant. Please remember that laws change, and the most up-to-date information is on our website at edn.la and in our empowerment classes.
My name is Calvin. I'm a new student of the EDN Tenant Empowerment Program. This video could be called The Eviction Process, When to Fight and When to Let Go, or The Eviction Process, How to Be a Powerful Negotiator, or The Eviction Process, the 16 factors to consider in deciding what to do in your case.
The Eviction Defense Network is a proud member of the LA County Right to Counsel Coalition and its Stay Housed LA program.
Hello, I'm Caro, a powerful student at the EDN Tenant Empowerment class. If you have a disability, including a learning disability, and need a reasonable accommodation, please let us know.
We cannot have social justice without language justice. Please help us by being patient with the interpretation. Unless we are interpreting simultaneously, speak one sentence at a time. Wait for the interpretation.
Hi, I'm David, a successful Tenant Empowerment Program student. Please attend our support groups on Fridays at 6 p.m. And at the support group, you can learn the following things. Number one, about technology and using Zoom correctly. 2, basic Zoom etiquette, like muting yourself and before you join, unmuting yourself until we call on you, stay muted, and how others and tenants have used the empowerment program to get great results. Now, I can tell you personally that I was scared and anxious before I came to these webinars, but now I feel empowered. I feel in control, and this is thanks because of the empowerment group. Now, we ask you to come each Friday if you're having these problems so you too can be an empowered support group member and attend the EDR Empowerment Support Group.
We know you're stressed. Eviction is one of the top 5 most stressful events you could go through. It is third after the death of a loved one and a divorce. Overcome your stress through knowledge and power. Watch the videos. Come to the webinars to learn the law. Come to the empowerment classes to learn the procedure and how to be a winner. Come to the tenant support group to get love and understanding and to be around people that have gone through what you are going through and were victorious.
You are here in our video series, Negotiation. Should I stay or should I go?
You should have already watched these 2 videos that explain exactly how you get legal help. If you have not, please stop and go back.
Our website is your best friend. It understands your plight. It's available to you 24 hours, 7 days. It never gets tired or impatient. It has all the information you need to succeed.
Click here for a list of our videos. Click here on the website to a step-by-step for each stage of the eviction process.
What to do at the first sign of trouble, including how to respond to a notice from your landlord.
How to respond to a summons and complaint from the court. How to respond to a notice to vacate from the sheriff. If you're not familiar with this diagram, please stop and go back and watch the first 4 videos. As you know from those videos, you can negotiate at any time, even after you have lost.
Early in the lawsuit, you need to decide what outcome you want. There are two possible outcomes. Start by asking yourself,
Should I stay or should I go?
bum, bum, bum.
If I go, there will be trouble. My rent will triple for starters. If I stay, it will be double unless I join my tenants union and ace. Hey, what happened to a pum 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 at the end?
Remember that the outcome, winning, losing, or getting a good deal, depends on how prepared you are.
Being prepared means knowing the laws that your predecessors in the tenants' rights movement fought so hard to get for you.
Preparing includes looking for housing and
Carefully document every unit you see. You should be looking for housing even if you're fighting to stay. It will give you an idea of what the market is like. If you carefully document your housing search, you can use that search. You can use this journal to do a hardship motion if you lose your case. You have to qualify for that motion, but it's this kind of evidence that we need to make it a good motion. And who knows, you might find something, putting you in a powerful negotiation position. You will note that this tenant is writing down the address, the name of the person they talked to, their telephone number, the price of the unit, the size of the unit, and all the details about what happened and why they didn't get the unit for every unit they've seen.
Preparing includes making a plan for paying future rent. It also includes into buying a home with any relocation funds and saved rent.
Contact Erica Torres at Haven Services. You can see her email address on the screen, Torres, ETORIZ, at havenservices.org. This is a HUD-approved nonprofit agency that helps non-traditional homebuyers.
Have a place to go before agreeing to move, but be realistic about your chances of winning. Be realistic about your goals and be flexible, especially as your case gets closer to trial.
If you have all or most of the rent you owe, bring it to court every time in certified funds. That's a cashier's check from your bank. It's less ideal to bring it in money orders. You need to look at our video on how to pay your rent like a pro. Many landlords will take money if you have enough and if you bring it to court with you, especially if they're facing the expense of a long trial. How much money is enough for them to dismiss the case depends on how much you owe and on the personality of your landlord.
when you come to us, we ask you to pick a path. On the left is the fight for my housing path, the fight to stay. On the right is the move out path. Yes, I will move if 1. You give me enough time to find a place. 2. Forgive the rent I owe so that I can make a fresh start. 3. Keep my record clean, meaning sealed, so no one will know about the eviction. And 4. Give me relocation assistance.
If you are on the move out path, you also have to figure out how much time you need.
And how much relocation money.
Insist on a sealed record.
And rent forgiveness.
Your settlement position has to be reasonable. If you hang the meat too high, the dog won't jump.
What is reasonable depends on the 16 factors in your case. If you have a strong case, good defense, the proof, good witnesses, and you live in a unit that is protected by a rent stabilization law, and you pay low rent, you can get a much better deal than if you live in an unprotected unit or don't have defenses or don't have proof of your defenses.
These are the 16 factors to consider. You have seen them in other videos.
Factor 1, the value of the unit. How much rent do you pay? How much for the space? In what neighborhood? If you found another unit like yours in your neighborhood, how much more would you need to pay? If you are paying less What's the most units like yours would cost in your neighborhood, then your unit is what is called below market.
Factor 2 is the unit protected. There are local rent stabilization laws, and we also have a weaker state rent stabilization law. And if you have a rent subsidy like Section 8, there are federal regulations that protect you. If these laws apply to your unit, they give you extra defenses to the eviction.
Factors 3 through 7. Can we win? Are there any legal defenses? Did you raise them in your answer? Do you have the evidence to prove your defenses? How good are the witnesses on each side? Are your defenses technical or substantive? If the landlord really wants you out, usually because they want to raise the rent, they will try to evict you over and over. A technical defense will get you a win in this case, but the plaintiff will be able to start again and try to evict you for the same reason. A substantive defense gets rid of the landlord's reasons to evict you entirely. If they want to start again, they have to have a new reason.
Factor 8. Do you have other leverage to get what you want? Did you make a jury demand and file a fee waiver too? Did you propound or send discovery to the landlord's attorney, which means that you ask them a whole bunch of questions they have to answer? Is there an unlimited attorney's fees provision in your contract? Now, how do these things get you leverage? We demand juries mainly because there are too many judges that are biased against tenants in our system. Sometimes we waive a jury if you draw a good judge. So important to have a jury lined up. But we also have to acknowledge that jury trials make it more expensive for the landlord. A bench trial happens in an hour or two. A jury trial takes at least 5 days. And that expense can be leveraged in negotiation in terms of discovery or sending questions to your landlord to answer. We do it because we need the information, but it does cost the landlord money to respond. Having to pay their lawyer to respond to discovery, combined with other factors, can make a landlord want to accept your offer, especially if you're bringing the money to court in certified funds every time. An unlimited attorney's fees provision. Does your rental agreement say that the loser has to pay the winner's fees? This is a double-edged sword with the blade sharper on our side because it's easier for us to collect a debt from a landlord than it is for the landlord to collect a debt from you. Often, the threat of having to pay us for our time as lawyers is a factor that will push the landlord into accepting your offer.
Factor 9, your finances. Do you look like tenant A, B, or C?
If you're paid under the table, that's tenant A, and have no social security number, it will be nearly impossible to put an eviction on your record or collect any rent that accumulates during the eviction. Remember that during the eviction lawsuit, they can't take your rent. If they take your rent, it cancels the eviction, but you owe it. It isn't called rent anymore. It's called daily rental damages. Daily rental damages is any rent that adds up, lawyers say, that accrues after the notice that is the basis of the lawsuit expires, which is another way of saying ends. That rent is hard to collect if you're paid under the table and you don't have a social security number.
If you're on government benefits, the evictions can be put on your record, but your income is what is called judgment proof, which means it can't be taken to collect or your rent debt. They can't collect any money. You don't want the eviction on your record because it will make it hard to find new housing, but at least the rent debt that builds up during the eviction lawsuit can't be collected. This is leverage in the negotiation.
If you are tenant C, you're temporarily poor and you need to protect your record. The rent debt that builds up can be collected when you get back on your feet. So can the other side's attorney's fees and costs. So you need to make sure that you have a winning case before deciding to go to trial rather than taking a settlement.
Factor 10. What are you risking? Is there a good offer on the table? Are you risking a job or career? Do you have a Section 8 voucher to protect? Let me give you a few examples. Think about how each example applies to your situation. Let me start by asking, 1, Is 3 weeks to move without any forgiveness of the rent debt and having to pay the other side's attorney's fees and costs a good deal? The only benefit in this deal would be a sealed record. Is that a good deal? Number 2, is 4 months to move with $33,000 in forgiven rent and $100,000 in relocation plus a sealed record a good deal? Most of you would probably have answered that the first case is a bad deal and the second one a good deal, and those answers are both not quite right. The answer is it depends on the 16 factors.
I once represented a young man living in a luxury unit in Marina del Rey. He was a stockbroker and an investment planner. He fell behind on his rent because he lost his job. He lived in a market rate, unprotected unit in Marina del Rey. The single most important thing to him was a clean record because job and career were at risk. Would you trust a stockbroker and an investment planner with an eviction on their record? No. So the best deal for him was that deal where he paid everything, but he got a clean record. Now, most of you probably answered yes to the $133,000 deal. The right answer is it depends. In this case, I actually think we could have done better. The owner was tearing down 4 below market rate controlled units and putting up 6 luxury condos. They had made a mistake on the paperwork, a technical defense, but we were sure to win, which would force the developer to start again with a new eviction, and that would delay construction and make the developer lose $300,000. So I thought we could get between $200,000 and $250,000. $133,000 is not as good as we could have done, but it was enough to put the client into home ownership on the west side. This was a while back where $133,000 still put you into home ownership on the west side. And the client was not willing to take a chance that they would take the $133,000 off the table. So it was a good deal for her, although not as good as we could have done. I once represented an elderly woman without a social security number whose only income was recycling and selling tamales. She had violated her lease and not cured or fixed the problem within the 3 days in the notice. The unit was protected by the Los Angeles Rent Stabilization Ordinance, and the rent was about $450 per month for a 1-bedroom in Mid-City, very below market rate. We had a hard-to-prove technical defense and the possibility of doing a post-trial hardship motion if we lost the case. We had no choice but to try to win. Any move-out deal would have put her in danger of homelessness unless she got enough money to buy a house, and for her, given her income and her source of income, that was not possible. Suddenly, they offered $50,000 on top of the forgiven rent. She turned that offer down, and fortunately, we won on that technical defense. But in a similar case, a family turned down $75,000 against my advice and lost. There was no way to do a hardship motion in the second case because the lawsuit was about a nuisance. And therefore, that was a very, very hard loss. And finally, the case of a tenant in a bootleg unit, a unit being rented without permits during the pandemic. In our view, the notice was defective because during the pandemic, the County of LA protections prohibited no-fault evictions. And this was certainly a no-fault eviction. It was not the fault of the tenant that the landlord was renting a unit without permits. Post-pandemic, the landlord would be able to evict by serving a 60-day notice to quit. The pandemic protections were expiring. She was entitled to 1 month's rent and relocation assistance. The tenant was asking for 4 months to move, forgiveness of the rent, a clean record, and $25,000. She was hanging the meat too high, but the risk of losing was low, and if we won, she would get more time. Things changed, and then during the pre-trial meeting that happens with the trial judge, just before the judge starts the case and calls the jury, the judge told us that he thought our analysis of the law was wrong and that the illegal use is always a health and safety concern, and therefore she could be evicted. The judge sent us out to settle. We were in the position where that can we win element shifted because the judge wasn't going to give us the right instructions for the jury. We ended up reaching an agreement of 60 days to move with a forgiveness of the rent and $2,000 and a clean record. The tenant could make this type of turnaround. In other words, she wanted more, but she could take this because she was prepared and had been looking for housing and had some possibilities. To get more example, watch the videos entitled The 16 Factors in Action.
Factors 11 to 16, the players. What is your landlord like? Is the landlord a principal of the thing, type that won't settle with the forgiveness of the rent no matter what? How rich are they? Can they keep going forward with the case, paying their lawyer while not getting any rent? What is the opposing counsel like? Are they a litigator that is ready to take the case to trial or a settlement type? How prepared are they going to be for each appearance? Who is your judge? You are assigned to a judge or commissioner now, but you may not stay with that judge or commissioner. Please make sure you watch the video called What to Expect on My First Day in Court. Who are the jurors like to be? If your case is in downtown LA, they will tend to be renters in rent-controlled units, and some will have had harassment experiences. In other courts, they tend to be homeowners. Do you have a lawyer? What are the chances EDN can step in? Are you prepared enough to win?
Before each court appearance and any time a factor changes, reassess whether or not you can still win.
You need to prepare each time you go to court by going over the 16 factors as they apply to your case. How much time you can get, how much relocation you can get, and if the rent will be forgiven depends on the 16 factors.
Negotiation is a combination of playing poker, chicken, and let's make a deal. You need to learn to play all three games well in order to get a good result. Prepare by watching poker tournaments on TV and by watching episodes of Let's Make a Deal. Pre-pandemic at Eden, we held staff poker games. I remember very clearly the day one of my staff members understood the concept when he folded saying, "The client did not bring in the evidence." You can have a great case with great defenses, a straight flush missing one card. But if that card does not come in, that is to say, if the client does not bring in the evidence, you're going to have to fold.
Work on your poker face.
Let me share with you my favorite negotiation ever. Keanu Reeves is an FBI agent that's been undercover in Patrick Swayze's gang of daredevil surfer bank robbers. Patrick is escaping over Mexico. Keanu has snuck onto the plane without a gun and without a parachute.
I know it's hard for you, Johnny. I know you want me so bad it's like acid in your mouth. But not this time. Adios, amigo! Fuck yeah! What? Pull the shit, Bodie! You are crazy! Pull the fucking show! Why don't you pull it? No games, Bodie! Pull the cord now! Now! Go ahead, Johnny, pull it. You gotta drop the gun, right? If you use your other hand, what are you gonna hold on with?
Pull it right now, or I blow your fucking head off and pull it myself!
The only way it's gonna happen, my friend. Do it!
Swear to God, I will!
Do it, man! Do it or you're gonna die, Johnny! 6 seconds! It's gonna be me, Waffles! 5, 4,
You fucking crazy!
3,
Pull it! Pull it!
1!
Shit! Shit!
Ask yourself this question. Who are you in this scenario? Who won in this scenario? Now, in reality, there is no right or wrong answer, but I will note this. When this class is taught live, most people want to be Patrick. Most people think Patrick won. Consider this, though. If both sides are Patrick, then they both die. Both sides die. The way this translates into your situation is this. You can only be Patrick if you're 99.9999% chance of winning. That's, in other words, it has to be exact on. And there is no case that is 99.999% chance of winning. There's always a chance that you're taking and you always risk losing. And it is usually more than 0.1%. So the moral of the story is don't crash and burn. The key is to know when the last possible minute to pull the cord is. Kanu knew and Patrick was nuts. He dropped the gun, pulled the cord right before they both became splat, hamburger meat.
If you want to move and you reach an agreement on when you are moving, you will need to write it up. This is the closure part of what we've been seeing on that slide in negotiation. You reached your agreement from a place of power, not from a place of fear. And now you need to use our forms and only our forms to close that deal. Mark, who was a client and now works at EDN, got the deal he wanted, but allowed the plaintiff's counsel to talk him into using the plaintiff's forms. And that put him in a very high risk situation for the record unsealing, because if he had made one little mistake as he was leaving in the last few months, the record would have unsealed. Our forms protect you from that. Don't be talked into using their forms or into adding or deleting terms without consulting us. On the day of each of your court appearances, if you come to an empowerment class just before that appearance, you will be given Eden staff numbers to text for advice while you're in court. In the morning at 8 o'clock, you're going to text those numbers at the same time, creating an email string that has you and those Eden staff members. Usually there won't be any problem reaching us, but if you can't reach us, don't make the deal. Ask for another date. Bring the issue to a Monday or a Wednesday empowerment class, and we will help you analyze it and we'll help you write up the changes. I once represented a woman who negotiated a $50,000 relocation deal and got a lot of rent forgiven. But she did not listen to me. I was totally against this. They insisted that they would only give her $50,000 if there was a provision that if she did not move on time, she would not get the second 25. So they were giving her 25 up front and 25 after she turned in the keys. The money was going to be in our trust account, but she didn't get it until after she turned in the keys. And there was a provision that if she didn't move on time, she didn't get it. She was supposed to be out at midnight, but she was still there cleaning the unit at 7:32 a.m. the next day when the landlord arrived. Now, she didn't even have to clean the unit. The agreement said that they took it the way she left it, but she felt bad, so she decided to clean the unit. We argued to the judge that she was out on time and was only there cleaning. The judge did not buy it. She lost the second $25,000. The agreement, as written, was off of our normal script. When I say don't go off script, it means don't make that change to the forms that we're giving you. If she had listened to me by either not going off script, which in this case was impossible. They were not going to give her $25,000 unless she agreed to this. But then she needed to move out on time, right? And we so stressed to her 1 minute late, 12:01, and you lose all that money. And she just didn't take that seriously. So she was still there cleaning at 7:32. Each element of the form is extremely important. The form comes with nearly 40 years experience, including horror stories like this one. Listen to Mark's cautionary tale on the testimonials page. He knew what he wanted and he got what he wanted, but then let the other lawyer talk him into using the other lawyer's form, which had terms in it that could have resulted in the record unsealing. As I said before, at the TEP classes, that's the Tenant Empowerment Program classes, before each court appearance, you will get numbers to call. Those cell phone numbers are for illegal lockout emergencies and to use the day of your court appearance if things start going wrong. You must send your PIP that morning at 8 a.m. to those numbers, and the last sentence of your PIP that morning needs to say, I'm in court in department whatever it is at whatever time, and that needs to be your last sentence that we know why you're sending it.
This is the form you would use to write up a move-out agreement.
Fill in the court where the blue arrow is. Put in the correct court address based on the court you're assigned. The address of the court is in your paperwork.
Fill in the landlord's name as it appears on the complaint. Do not write in greedy landlord. Write in your plaintiff's name.
Fill in your name as it appears on the complaint. If it's wrong on the complaint, it has to be written exactly the same way here, wrong, or the clerk won't be able to find the case.
Right here, fill in your case number.
Fill in your department number. If you've been transferred from one department to another department,
Write the original department and then transfer to department and then put in the new department number.
put in your name. Please note that this says that you are losing the case today, but the record is sealed. No one is going to know that you've lost. If you don't move, the sheriff can lock you out the very next day after your move out date. Our experience is that 33% of you are not going to move on time. This wording forces you out of the place. But in exchange, you get a guaranteed sealed record and your rent is forgiven even if you don't move out on time. And this is a better benefit to you than getting a couple of extra days or even weeks. The other option is to say that a judgment will only enter if you don't move, but then the other side will want as a consequence or punishment that your record will unseal and the rent won't be forgiven. And frankly, it's not worth it.
If there was a mistake in the complaint, here, you put in your correctly spelled name and then sued herein as fill in the incorrect name.
Add all the defendants that are signing.
Leave all the zeros. We are fighting for forgiveness of rent. If they will not forgive the rent, come back to an empowerment class so we can help you figure out what to do.
Do not change or delete the word obligations where the blue arrow is. A tenant who did not include this word was later sued for damages for other violations.
Put your address here where the blue arrow indicates. It must be exactly as it appears in the complaint.
You need to negotiate whether or not they're going to return your deposit. Because they're forgiving the rent, they usually want to keep the deposit. But if you paid a very large deposit, think about asking for some of it back. If you manage to negotiate that they will return the deposit, and even if they don't, you need to carefully document the condition of the unit. You're not actually negotiating a return of the deposit. You're negotiating that they will follow the law, which gives the owner the right to inspect and deduct anything beyond reasonable wear and tear from the deposit. So you need to document the condition of the unit carefully. Ideally, when we move into a unit, we should take videos and photos of close-ups of defects. And when we move out, we should take long shots to show that we're turning it substantially the same way we got it, except for reasonable wear and tear. Most people don't take photos when they first move in. And so landlords can falsely accuse them of things being broken that were already broken. So they always find something to deduct from the deposit, but nonetheless, you should document how you left the unit very carefully.
Here, you put the date you are moving.
Here you put the day after the day you are moving, and that's the day the sheriff can lock you out if you don't move on time.
Always write your initials at the bottom right corner of all the documents. This will reduce the risk that someone will change out a page.
We call this second page, the insert. Every word on it has a purpose. If the other side wants to make a change, text us. If the change is too complicated, remember that you don't have to make a deal today. Come back to the empowerment class so we can help you figure out what to do. Let's review each paragraph.
Paragraph 1. We want the record unconditionally sealed. Statistically, 33% of you won't move on time. We therefore want the record sealed whether or not you move on time. If you don't move out on time, the sheriff will lock you out the next day.
Paragraph 2. We want to avoid false claims, false accusations that you did not move on time. So what we say in our stipulation is no particular act is required to demonstrate, which means show, that you moved out on time. The return of the keys is not a material term. We want to get the judgment against you changed to a dismissal as soon as you've moved. So we schedule what we call an OSC, order to show cause re dismissal. An order to show cause re dismissal is a hearing where you come and show that you moved on time. And if you do, the case will be dismissed or canceled. We don't want to get rid of all the good things in the stipulation for judgment, like the forgiveness of the rent. So we say all other terms of this stipulation for judgment shall remain in effect. Both sides are reserving any right they may have to sue each other. So we say the dismissal of the case is for credit purposes only and may not be used by the defendants against the plaintiffs as an admission of culpability. All that means is if you sue the landlord later on for something else, the fact that they dismiss the case can't be used against them.
Paragraph 3. There are various ways that you could try to get more time to move, but judges rarely give more time. By signing this agreement, both sides are buying certainty. We make that clear by saying that you can't get more time, and if you try, the file will unseal. One of the ways you could theoretically get more time is a motion for a new trial, CCP code 657, but there was no trial. You signed an agreement. This motion is not available to you. Reconsideration, CCP code 663. The judge made no decision, so this motion is not available to you either. Relief from forfeiture, CCP code 1179. This is the motion we use for cases with below market rate, rent stabilized tenancies. If we don't win, we make this motion. By agreeing to move, you are giving up the right to make this motion. Hardship extension, CCP code 918. The judge can let you stay up to 40 days from the date that the judgment is entered against you. This is not available to you both because you are giving up by signing this agreement and because we usually negotiate more than 40 days to move. To stay of execution, pending appeal, you have nothing to appeal. You are signing an agreement. Bankruptcy stay. If you file for bankruptcy, there is an automatic stay of execution for a few months. You can't really be asked to give up your right to declare bankruptcy, but if you do, this eviction file will become public.
Paragraph 4. Normally, you get 15 days to get your things out after the sheriff locks you out. Again, both sides are buying certainty. And paragraph 4 makes it clear that you are giving up those 15 days. Therefore, you have to make sure you are negotiating enough time to move. In fact, we very often tell you, don't negotiate a move-out deal unless you have a place to go. Now, as you get closer and closer to trial, we often have to soften that position, but make sure you're negotiating enough time or you have a couch surfing situation to go to.
Paragraph 5. It makes it clear that the owner is waiving or forgiving all rent you could owe. They can't claim that 3 years ago you missed a payment. Landlord's attorney will say that this paragraph does not matter because it says 0 on the front page. That is 100% false. The front page says that there is no money judgment in this case. It does not say that they won't go after you for other money. To make sure that they don't claim you owe other rent, you need this language.
Paragraph 6, the owner is forgiving the rent and will likely want to keep the security deposit. But if they sue you for damage to the unit beyond reasonable wear and tear, this puts the deposit back into play to pay any judgment that they might get.
Paragraph 7, landlords sometimes want to start getting the unit ready for the next tenant. Paragraph 7 makes it clear that there will be no entries for repairs unless you request the repair.
Paragraph 8, references that you were a good tenant are important to help you find housing, but the owner is not going to give you a positive reference. They are afraid that if they give you a positive reference and the new owner finds out that you've been evicted, that they can be sued. At best, you're going to get a confirmation of the dates you live there.
Paragraph 9, the parties are not always together in one place to sign one document. This paragraph allows you and the owner to sign different copies of the same agreement.
Paragraph 10, if you're able to negotiate that they're going to pay you relocation funds, this paragraph is necessary. The owner's attorney will want to change it to an exchange of funds for keys on your move-out date. We'll give you a money order or cashier's check. You give us the keys on the move-out date. Do not, under any circumstances, allow that. You will never see the money. The date they give you the funds should be no more than 3 weeks after you sign the stipulation for judgment and no more than 3 weeks before you move. It should be payable to you. It must be a cashier's check because checks can bounce and money orders can be canceled.
Paragraph 11 talks about attorney fees. It is important only if they are giving you funds. If the money is not paid, you want to be able to go to the judge and to get paid, and you want to be able to recover attorney fees to do that. Otherwise, it's okay to cross this out if they don't want it.
What that means, I'm realizing it's not very clear. If they're not giving you money, then we don't care about that provision. But if they're giving you money, that provision is important. Paragraph 12 means that the judge will continue to have power to do whatever is needed to make sure everyone does what they're supposed to do.
Paragraph 13, often there are extra people who are sued. People who moved out and you can't reach, for instance. This protects them so that the owner can't go after them for the rent and daily rental damages.
Here, where the blue arrows are, you fill in the dates and you get signatures.
Make sure that the clerk gives you a return date. We call it an OSC, redismissal. And the date, if you have moved, the entry of judgment against you will be set aside in the case dismissed. That way, if the case ever accidentally unseals, the record will show that the case was dismissed rather than a loss for you, the tenant.
Sometimes landlords are willing to negotiate what we call pay and stay deals with a payment plan. Be very careful. Payment plans come with the threat of an immediate lockout if you're even a little bit late in one payment. I've had tenants who have paid $10,000, everything paid, and then they're late on their second to the last or last payment. So, and if you don't make the payments, they also threaten to unseal the record. And sometimes that you will owe all the rent even though you've been kicked out. We have countless of tenants that thought that they could pay on a payment plan and then something went wrong. So try to persuade the landlord and the landlord's attorney to take the payments going forward, the future rent, without prejudice to their right to proceed with the eviction if you miss a payment. What that means is if you miss a payment, then they get their trial, but you don't get kicked out. It puts you right back where you are today, trial going forward. So you would say to them, I would like to pay and stay. I would like to pay my future rent starting. Tell them the month and make sure that you really can do it starting that month. I would like to pay however much money you think you can reasonably do and safely do towards my back rent each month starting. Tell them when. But I will not sign a stipulation for entry of judgment. I will not sign an agreement that means that I'm locked out if I miss one payment. I propose you dismiss, so try to get them to cancel the case, but we could also ask the court to just continue the case. That way, if I miss a payment, you can drag me back in here to do a trial, and we could do it on 2 weeks' notice. The trial will be based on my original defenses, and then here's the proposed agreement. We've written it up for you. You can print it. You should print 4 and keep them in your notebook.
This is the document needs to be signed in order to finalize the pay and stay agreement. If you want this type of deal for yourself, fill out what you can fill out today and leave what you don't know blank. Insert your name, address in the header and caption. Make all the changes you need to make. Number 3, print. Print 3 and take it to court with you. Fill in and print today. Do not agree to more than 10% interest and try to get the interest as low as possible.
The key to success is preparation. Remember that journal we asked you to buy the first day you met with us, the first video you saw? Be diligent. If someone says something that doesn't sound right to you,
Come check it out with us at an empowerment class.
don't misuse the cell phone, or it will not be available to you the day of your next court trial.
Follow instructions and do things right because success in negotiation comes from being prepared. Stop the video and read the journals.
Prepare your exhibit notebook. You should have already started this as soon as you met us. If you have not, start it today. Buy the notebook, buy the dividers, hole punch all of your evidence except what are true originals, like a marriage license, a birth certificate, a death certificate. In that case, make a copy and hole punch the copies and put them where they belong. Put them, all your exhibits, under the tabs that are indicated here on this table of contents. For communication between the parties, divided into 3 sections, text, emails, and letters, but you put all 3 sections under 103. Do not number anything yet. Watch our video on how to prepare the perfect exhibit book.
Prepare your trial notebook. You will need to merge it with the plaintiff's notebook. See our video on preparing the trial notebook.
There are many types of appearances in court. Hearings, appearances. You need to know why you're going to court on any given appearance date. The initial trial date is either set for a jury or a bench trial, but there, likely, you will get a mandatory settlement conference, especially if you ask for one. If you don't settle, you will get a trial setting conference and eventually a final status conference and a trial. Also, we've already talked about discovery. That's when they send you questions to answer. But in the criminal context, they call discovery the process of exchanging your trial exhibits. And some of our judges come from the criminal courts, and sometimes they will say the discovery exchange is on X date. Politely ask, Your Honor, I'm confused. Do you mean the trial notebook or do you mean actual discovery? It's very confusing to tenants, and we want to make them aware that in the civil context, discovery is when they sent you questions and you answered them, and that happened before you even came to court the first time. And trial document exchange is this process of each side giving each other what they're actually going to use for the trial.
In between court appearances, practice your negotiation skills, especially that poker face.
Know where you fall on the 16 factors and redo them every time there's a change in the situation. Know your settlement position well. And if we ask you, where do you fall in the 15 factors, be able to say, I want to stay or I want to go. And if I'm going to go, here are my terms.
The Mandatory Settlement Conference, or MSC, is a true negotiation session, often with a mediator.
The trial setting conference is like a check-in meeting to see if there's still room for settlement, and if there isn't, to see if your trial notebook is done and ready and fully merged and ready to start the trial. The final status conference comes with a strict order to come back ready with a fully merged notebook, all your documents, and ready to go to trial.
The jury is in the shower when you have a merged notebook and the clerk is looking for a judge to take the case. If you want to settle, the moment of truth is coming. You may need to start softening your settlement position or your demands.
The jury is in the elevator when your trial is starting today or tomorrow.
This is your last chance to make a deal before the trial starts. You have more information. You know your judge. You know what your potential jurors look like. In downtown LA, they are likely to be tenants, many in rent-controlled units, and have experienced harassment. In other areas of the county, your jury pool will be more homeowners. You also probably know if you have an attorney to represent you.
Reassess the can you win factor. Do you have all the evidence you thought you were going to have? Do you have all your witnesses that you thought you were going to have? Now that you know your judge and your jury pool, can you still win? Do you have a lawyer? And if not, did we prepare you sufficiently to win on your own? Were you at the last Eden Zoom event, preferably the Monday, Wednesday, or Saturday? And is there a chance that an Eden attorney can step in? We are a ship in a storm, and we haven't quite figured out what to do with the cases that where there's absolutely no one available to do the trial. People often ask, how often do I have to come to the classes? You don't have to come at all. You should come as often as you can. You will learn something new every time. You will absorb not only information, but a feeling of confidence. Don't be like our student who was smart and educated and well organized and busy and thought she could cut corners and come sometimes and be in and out of the classes. In the end, she had not absorbed enough of the winning spirit or enough of the skills because she had not practiced them consistently. After a day of jury selection where we were guiding her by text, she felt like she had to take a deal. We guided her through the negotiation via text to a decent deal, but she did give up a below market rate apartment. That probably would not have happened if she had been a better Tenant Empowerment Program student. Please join us on Monday and Wednesday at 5:30, Saturdays at 8:30.
Our community is a ship in a storm. We are taking on water, and our lawyers are in the water rescuing others.
We can only give a lawyer or assign a lawyer to 10% of the people who need lawyers. That means that 9 out of 10 of you need to learn to swim.
Help us bail water by educating yourselves. These empowerment classes and webinars will give you the knowledge and skills you need to survive until a lawyer frees up or until you are strong enough to represent yourself.
We are available to you 6 days a week.
Help us be efficient at the empowerment classes and webinars by watching how to get legal help on our website.
And by reviewing from Zoom to Victory before every class you attend.
You need to know how to rename yourself.
And you need a current, up-to-date PIP that's ready to post in the chat when we ask you to post it.
We are fighting for a better tomorrow.
A future where there will be enough lawyers for everyone.
Join our tenants union and ACE.
In the meantime, we're recruiting hundreds of tenants that have gone through the process successfully and are willing to help others. We are also recruiting organizers in tenants unions and in organizations like ACE, teachers, the faith community, labor unions, and the staff of social agencies and service organizations.
Remember, use your banning email string, reply all, But if we don't get back to you, you need to come to the empowerment class webinar and we'll take care of it.
If you're confused and need emotional or moral support, please go to a tenant support group meeting. Be a winner. Attend our empowerment classes and webinars regularly. Together, we can all be winners.
Arrive on time.
Mute and rename yourself as soon as you join.
Watch our videos over and over and take notes. It takes multiple times to absorb the information.
Come prepared with your current PIP, ready to put it in the chat when asked.
Come prepared with your trial notebook and exhibit notebook. The trial notebook has all of your court papers. Your exhibit notebook has your proof. Watch the videos on how to put them together.
Memorize your case number, your opponent's name, opposing counsel's name, and department number. We are not going to waste time listening to you shuffle through papers to find the information.
Listen carefully when we are answering questions from other tenants. You never know when another tenant will ask what you were going to ask. And if you do, please don't ask the same question. You also never know when another tenant will ask something you wish you had thought to ask.
Be respectful of the attorneys, the staff, the volunteers, and other tenants.
Practice your late night FM DJ voice.
Practice your poker face.
And memorize the ship in a storm speech, because together we can all be winners.
We look forward to meeting you at tenant empowerment classes and at the webinars. And remember,
When
When
we
we fight,
fight,
we win.
we win.
we win.